Ladies and gentlemen, dear colleagues, on behalf of the ECB Executive Board and on my personal behalf, it is my pleasure to welcome you in Frankfurt and at the ECB to this ECB Legal Conference. 11 years ago, the ECB Legal Services organized the very first of these conferences, and what began as a rather specialized meeting for central bank and EU lawyers became something of a tradition, a point of reference for lawyers from institutions, academia, and practice. Every year at the beginning of autumn, we convene in Frankfurt, now sometimes virtually, but this year we have the pleasure of being here in person, to exchange ideas and ask questions. The themes we have explored over the years have reflected shifting challenges of the ECB and of the Union itself. The Eurozone crisis, emergency measures, the banking union, the balance of competence. Each of these themes reflected in its own ways the challenges of its time and showed that the central banks is never isolated from the broader issues and constitutional and political challenges of the Union. As we prepare this year program, we realized that the issues that are on our desk and your desk can be all seen through a certain lens, a common lens, the pursuit of European autonomy. From the digital euro to the internal market, to the resilience of payments, the pursuit of European autonomy provides a unifying thread for many of the challenges that Europe faces today. But what do we mean by autonomy? Autonomy has been something like the holy grail of the European integration. For Europe to be autonomous means to be able to pursue European values and interests. And that requires independence, both for some institutions of the Union and for the Union vis-à-vis the wider world. This is a long process unfolding in many phases. Already in 1989, Jacques Delors made a powerful call for autonomy, and I quote, "Let us be powerful enough to command respect and to promote our values of freedom and solidarity. Neither the European community nor the peoples and nations that form it will truly exist unless it is in a position to defend our values, to act on them for the benefit of all, to be generous." Unquote. Autonomy also formed the background of some fundamental judgments of the court, from Van Henen-Loos and Costa Enel through ERTA, Opinion 191 and Achmea. The court has steadily shaped autonomy into a constitutional principle of the Union. In the early judgments, the focus was mainly inwards. The court was mainly concerned with establishing the self-sufficiency of the EU legal order. Autonomy meant the construction of a system where the EU law ruled over and beyond national law of a European rule of law. This European rule of law was necessary as a condition for the internal market and thus as a precondition for Europe's economic autonomy. At this stage of autonomy building, the focus was mainly internal, to create European autonomy vis-à-vis national interests and values. Later, autonomy was invoked against external influence in intra-European arrangements. In Achmea, the Court of Justice famously declared investor-state dispute settlement mechanism in intra-EU bilateral investment treaties incompatible with the principle of autonomy of EU law and the rule of law. Here, the rule of law served as an argument to protect autonomy. Today, autonomy has taken another dimension. The world has become more unpredictable, less cooperative, and at times openly hostile. In this context, autonomy means something very concrete and urgent. Europe's capacity to assert its voice on the international stage rather than simply adapting to the strategies of others. This can be seen as the next stage in the pursuit of European self-determination. This additional step, with a stronger geopolitical dimension, might have looked improbable some years ago. But today, geopolitical context has made it a necessity and perhaps a unique opportunity to foster a step forward in European integration and autonomy, as President Christine Lagarde has noted in several of her speeches. Yet autonomy has also a darker side. In many places, we see it invoked as isolation, mistrust, power concentrated in the hands of strong men, they normally are men, unchecked by institutions or the law. Around us, we see this version of autonomy, which I think is better qualified as autocracy. They also call themselves sovereignty or nationalism, we first, but they often mask authoritarianism, mistrust to diversity, sometimes even racism and dangerous flirtation with totalitarianism. In such cases, autonomy becomes the enemy of the rule of law rather than its companion. And so the question before us today and tomorrow and next year is a very real and pressing one. Can there be a European way of pursuing autonomy that remains faithful to the rule of law and to international cooperation? Or is autonomy always purchased at the price of bending law to political necessity, treating international rules as nuisance or at best strategic tools? My own conviction is that there can be a European path. Autonomy, the rule of law, and multilateralism are not competing projects. They belong together. They are, in fact, part of what Europe is. The rule of law stands at the very beginning of our constitutional order in Article 2 and Article 3.4 of the Treaty of the European Union. It obliges us to remain a rule of law polity even in the most difficult battles and against the most malicious adversaries. That is not only a legal imperative, but is also a matter of prudence. Just think of it. What chance would the digital euro have if trust in the ECB independence were questioned? How could the euro play a meaningful role in the international system if Europe did not project respect for international law? How could we expect foreign investors to contribute their wealth into European projects and citizens to trust their institutions if they were not reassured that independent courts will protect them fairly and impartially? Let me repeat, the pursuit of European autonomy can and must occur with due regard and with the support of the rule of law. In this year's conference, we have selected 6 areas where we believe these questions come more obviously to the forefront. Panel 1 looks at budgetary autonomy, the EU borrowing and taxation, the multi-annual financial frameworks, the next generation EU, the EU peace facility, and the link between EU funding and the rule of law. Panel 2 turns to autonomy through the internal market and capital markets union. It will examine the capital markets union, new emergency instrument, and initiative like the CHIPS Act or the defense industrial strategy, how they can strengthen European independence. Panel 3 will look at resilience, autonomy, and cooperation in payment and clearing systems, covering also the development of the digital euro. Later today, we will hear a keynote of Professor Suzanne Baer on the rule of law in 2025. Having Professor Baer, who has dedicated her career to the rule of law, diversity, and fundamental rights, deliver the keynote at a time when these values are under a challenge elsewhere, sends a clear signal about where the ECB stands in this debate. At dinner, we will hear President Christine Lagarde, who, as a lawyer by training, is very sensitive to these legal issues and can also bring some more wisdom on how these ideas are being discussed at the highest possible level. Tomorrow, we have panel 4 that will address extraterritoriality, equivalence, and mutual recognition, a vital discussion for banking supervision and crisis management in a world in which banks and payment systems go beyond borders, and the rule of law is the basis on which international cooperation in this field stands. Panel 5 will explore sanctions, tariffs, and blocking status, the new front line of economic law and policy, where it is sometimes challenging to reconcile the need for action and the respect for the rule of law. Panel 6 will compare developments in Europe and the United States on the question of independent administrative discretion and the rule of law, and of the role of the balance of powers in ensuring autonomy and protecting the rule of law. And finally, we will have a roundtable, which will reflect on the role of EU legal services in building autonomy. Several of us are part of these legal services, And if autonomy in Europe is to be grounded in law, in institutions, and in cooperation, then the role of legal service of these institutions is central, defending independence and balance of powers, upholding legality, and contributing to the development of the legal interpretation and reconciling strategy with law. So, ladies and gentlemen, let me invite you to fully engage in the discussions ahead. Our purpose today and tomorrow is not to lecture, it is to spark dialogue. Our panelists, and I would like already to thank them all for the time and commitment they put in this endeavor, will set the stage. But the real value lies in the exchanges that will follow. That is why we make sure there is ample time for discussion after the panels among all the experts in this room. The other purpose of this conference is to ask questions and forge a relationship that will continue after the conference. Our hope is to plant seeds for reflection and collaboration that will grow the months and the years to come. Autonomy, the rule of law, and multilateralism are the foundations of Europe's future. It is our responsibility as lawyers to ensure that they evolve together. This conference is only the beginning of this continuing conversation. I wish all of us an inspiring and fruitful conference. Thank you very much.